gentlemen, dear friends, it's a privilege and an immense pleasure for me to be here with you in Lviv today, to share with you some thoughts about competing fundamental rights in the context of a digital age. The famous Latin American author Gabriel Garcia Marquez once said all human beings have three lives: a public, a private, and a secret life. Let me, just before starting my presentation, reveal you some aspects of my public life and maybe one aspect of my private life. Before taking up my duties at Strasbourg Court, I have been representing the Dutch government before that court. I worked as a lawyer for a Dutch law firm, and I worked as a judge in civil courts in the Netherlands. I visited many newer member states of the Council of Europe to share with you some information about convention topics. But I have never had the chance to visit Ukraine, so I'm very thankful for this invitation. Last night, my husband was able to join me, enjoying the wonderful food and the great hospitality of the people of the city of Lviv. Turning back to the topic of my presentation, balancing right in a digital age, I know that balancing may take different forms, but two fundamental rights are conflicting with each other. For instance, the right to freedom of expression and the right to privacy. A classic balancing exercise will involve weighing those two rights against each other in the particular circumstances of the case. In other cases, where interference with an individual's fundamental rights is thought to be justified with reference to a general legitimate societal value or public interest, limitation of that right falls to be assessed with reference to the necessity test and proportionality review. Judge Ghana and Medviska has just provided you with examples on how privacy rights are balanced against national security interests. Coming to the digital part of the title of my presentation, needless to tell you that due to technology developments, we live in a different world than 20 to 30 years ago. The online world is almost taking over the offline world. The omnipresence of social media, the internet, mobile telephone communications in our daily life has transformed social, political, and the legal landscape. With one click on the button, information, images are disseminated across many jurisdictions. Children, teenagers, adults resort to Facebook, Twitter, Snapchat, Instagram, Messenger, WhatsApp, sharing messages, photos, and videos, usually with having no to little knowledge or awareness of whether their privacy or that of others is sufficiently safeguarded or what the legal consequences could result from any content. Even for cautious technophobes who shun social media, most of the things we do now, both on and offline, leave digital traces. It may be obvious that this new phenomenon creates challenging legal questions. While these questions first will be raised at national level before you, some of these have already reached the Strasbourg Court. As time is limited, I will confine my presentation to recent cases on balancing freedom of expression with the right to respect for private life related to the Internet's context. As a matter of principle, these two rights are said to deserve equal respect, with the result that the court has stressed that the outcome of the balancing exercise should not vary according to whether a complaint is lodged under Article 8 or Article 10 of the Convention. The scope of private life. Ghana, in her presentation, has already expressed to you what is the concept of private life according to the case of the court. On the slide, I just noted some of these aspects. One of these aspects, you know, is that it also includes a person's reputation and personal honor, although, according to the case, court's case law, the attack on a personal honor or reputation must attain a certain level of gravity in order to fall within the scope of Article 8. For example, in the case of Searle versus Estonia, information about the applicant's previous employment as a KGB driver was published in the paper and internet version of the State Gazettes of Estonia, and the court held that the published information affected the applicant's reputation and therefore constituted an interference with his private life. It also includes elements relating to a person's rights to his image, which means that photos and videos fall within the scope of Article 8. Moreover, the rights to protection one's image presupposes the individual's rights to control the use of the image, including the rights to reviews, publication thereof. An interesting question is whether the concept of private life also includes the rights to be forgotten. I will come back to that aspect later on in my presentation. Although the Convention stipulates that the rights to private life may only be interfered with when foreseen by law and with a legitimate aim, and whether it's necessary in a democratic society, this right is not an absolute one, and it may clash to other fundamental rights, such as the rights to freedom of expression. According to the consistent case law of the court, the right to freedom of expression is said to constitute one of the essential foundations of a democratic society. Subject to limitations in paragraph 2 of Article 10, freedom of expression not only applies to information and ideas that are favorably received or regarded as unoffensive, but also to those that offend, shock, or disturb. The broad scope is considered necessary to support pluralism, tolerance, and broad-mindedness, without which there is no democratic society. For the same reason, the need for restriction of freedom of expression must be established convincingly in the form of relevant and sufficient reasons. A high level of protection is accorded to freedom of expression in two fields: political speech and in matters of legitimate public interest. Matters of legitimate public interest involve, for instance, the functioning of the judiciary. Perhaps you may remember the case of Kudeshkina versus Russia, a judge from the Moscow City Court who in an interview publicly criticized the functioning of the prosecutor and the court in a corruption case, was disciplinarily removed from office for raising this issue. The Strasbourg court held that her dismissal was a disproportionately severe penalty, which was moreover capable of having a chilling effect on judges wishing to participate in the public debate on the effectiveness of the judicial institutions. And the court found in that case a violation of Article 10. The vital role of the media in facilitating and fostering the public's rights to receive and impart information has been repeatedly recognized in the case of the court. It's considered that, were it otherwise, the media would be unable to play a role as a public watchdog. This case law has been developed in the context of what we now call the traditional media. Information shared by the journalists in newspaper articles, in radio or on television. Nowadays, the question may arise concerning who or what constitutes a watchdog in the digital age. The internet does not transform all lovers and popular users of social media into recipients of privileged Article 10 protection. However, it does blur the line between journalists and others. At this point, it's worthwhile to reiterate that the court made it very clear that a high protection issues of public interest is subject to the proviso that they act in good faith, on an accurate factual basis, and provide reliable and precise information in accordance with the tenets of responsible journalism. In the Grand Chamber case of Stoll versus Switzerland, the court, referring to the elements of duties and responsibilities included in the second paragraph of Article 10, held, and I quote, "In a world in which an individual is confronted with vast quantities of information circulated via traditional and electronic media and involving an ever-growing number of players, monitoring compliance with journalistic ethics takes an added importance. In this respect, a clear distinction exists between journalists on one hand and bloggers and ordinary people of the public publishing on internet fora and in discussion boards on the other, as the latter are not bound by codes of ethics for journalists or other such rules." Here thus another question related to our digital age arises. What should be the interpretation of the elements, duties and responsibilities included in the second paragraph of Article 10 in this context? Answers to that questions are being developed. In the Grand Chamber case of Delphi versus Estonia, for instance, the court was confronted with the question of duties and responsibilities of an internet news portal, which disseminated like ever before, worldwide, in a matter of seconds, and sometimes remained persistently available online. The court further held that although not publishers of these comments in the traditional sense of the word, internet news portals must, in principle, assume duties and responsibilities. But because of the particular nature of the internet, those duties and responsibilities may differ to some degree from those of a traditional publisher. When examining the necessity of the interference with the news portal's freedom of expression, the court firstly took into account the balancing criteria that it has already elaborated in its case law, since as a starting point, protection of fundamental rights online should be the same as protection of those rights offline. And these balancing criteria relate to whether the publication contributes to a debate of public interest, how well known the person concerned is, and what the subject of the news reports, the prior conduct of the person concerned, the methods of obtaining the information or photos and its veracity, the content, form and consequences of the publication, and where appropriate, the severity of the sanction imposed on a party claiming an interference with the freedom of expression. Secondly, the court listed further factors of relevance relating to the potential impact of the internet medium. These relate to the context of the comments posted, the difficulty in establishing the liability of the actual author of the comments as an alternative to the intermediary's liability, and the measure applied by the company when aware of the nature of the comments. In the circumstances of the Delphi case, the court found no violation of Article 10. Like domestic courts, the nature of the comments and the fact that the Delphi company did not immediately retracted these comments or did something about it was decisive in the balancing exercise. Allow me to say a few further words on the question of whether there exists the right to be forgotten. In a digital age, it appears difficult to appear from your past. As I said before, most things we do, online or offline, leave digital traces. In 2014, the European Court of Justice in Luxembourg, the Court of the European Union, delivered a judgment in the case of Google Spain. It held that EU data protection law provides for a right to be forgotten online. According to the Court of Justice, this right extends to inadequate, outdated, irrelevant, and excessive data, and applies even where the search results link to lawfully published content, which remains available elsewhere. The Court of Justice did engage in a balancing exercise, and the right to be forgotten was not considered to be an absolute one. However, it further considered that the rights to privacy and data protection override as a rule not only the economic interest of the operator of the search engine, but also the interest of the general public in having access to that information upon a search relating to the data subject's name. The Strasbourg Court has not yet had the chance to examine the same factual situation as in the Google Spain case. It has, however, tackled the question of removing materials from newspaper internet archives. And I will give you a few examples of that. Times newspapers lodged a complaint under Article 10, stating that the British Internet Publication Rule, which required that a notice should be attached to the archived copies of material that had been qualified by courts as defamatory, infringed with the rights of freedom of expression. The Strasbourg Court considered first that while the primary function of the press is to act as a public watchdog, it has a valuable secondary role in maintaining and making available to the public archives containing news which has previously been reported. It further noted that the margin of appreciation afforded to states in striking a fair balance between competing interests is wider where it concerns news archives of past events than where it concerns reporting on current affairs. Applying this principle in the case at hand, the court considered, like the domestic court of appeal, that the requirement to publish an appropriate disclaimer to the article contained in the Internet archive constituted a proportionate and therefore justified interference with the newspaper's right to freedom of expression. In a Polish case, the applicants alleged that the fact that the domestic courts had not ordered to remove an article from the newspaper's Internet archive, although they had won a defamation suit against the newspaper, was in breach of their Article 8 rights. The Strasbourg Court found, however, no violation. It held that the judgments by the domestic court declaring that an article to be in breach of the applicant's rights had not created a legitimate expectation that the article would be removed from the newspaper's archive website. Also, it agreed with the domestic courts that it was not their role to engage in rewriting history or ordering to remove from the public domain all traces of publications which have in the past been found defamatory by final judgments of domestic courts. In such situations, a comment on the article's webpage informing the public about the outcome of the defamation proceedings was held to be sufficient. In a very recent case of June this year, the court rules in a German case, the case of ML in Germany and WW versus Germany. This case, the applicants sought protection of their privacy rights as their prison sentences for the murder on a very popular actor came to an end. They sought to require 2 newspapers and a radio station to remove from their internet archives references to reports in which their crimes and names were discussed. At least they wanted to have their full names removed from the archives. While the lower German courts upheld their claim of a violation of their rights to privacy, the Federal Court of Justice upheld the appeals introduced by the media on the grounds that the lower courts had not taken sufficiently into consideration the right of freedom of expression and in this context, the public interest to research past events. Referring to the margin of appreciation to domestic authorities and the fact that they had struck a fair balance between competing rights at stake and adduced sufficient and relevant reasons for their decision, the Strasbourg Court found no violation of Article 8. The court explicitly noted that this case differs from the Google-Spain case, as the latter concerned the operation of a general search engine, while in the present case concerns archived press publications, which publications were, moreover, not traceable to such general search engines. It further observed that the applicants, when requesting reopening of their criminal proceedings a few years before their release, had actively sought contact with the media themselves and had provided documents to the media. The court held that for this reason, the applicants at the moment of their release could not be regarded as purely private persons. It further held that as a consequence of contacting and providing information to the media, they could not have had they could only have held, I have to say it correctly, a limited legitimate expectation of having rights to be forgotten. To sum up, the aforementioned examples of the case law of the court show that the risk that internet poses on data protection and privacy rights has been recognized. It also demonstrates that those transmitting information through the internet, including those who run news portals and internet fora, must assume duties and responsibilities. At the same time, however, it appears from the court's case law that the existence of this risk posed by internet on the rights of privacy does not justify a downgrading of the fundamental right of freedom of expression. It does not prioritize rights to be forgotten without due consideration to the potential wider impact on freedom of expression. Internet and social media provide us with many opportunities, but at the same time also with legal challenges. As domestic legislation is adopted to respond to these challenges, one can expect in the coming years a considerable development in the case law on balancing rights in the digital age, both on domestic and European level. Hopefully we might have a chance to meet again in a couple of years to discuss this case law developments. For now, I thank you for your attention.
Thank you, Yoli. You are exactly reached 30 minutes. Thank you for being in time. Дорогие друзья, у нас есть 20 минут. Если есть вопросы, пожалуйста. То есть все понятно, да?
I would be very interested to know if you have dealt with cases in which these two competing interests were involved in this internet era context. So if these questions have indeed reached you at domestic level, if so, it would be very interesting to hear from you how you dealt with it.
Там не мерещится или рука была? Но вы будьте более, чтобы мы вашу ручку видели. Пожалуйста, представьте.
Дякую. Питання. Градова Юлія, доцент Харківського національного університету імені Каразіна. У мене таке питання. Чи підпадають справи стосовно кібербулінгу під статті 80 Конвенції? І чи зіштовхувався Європейський суд з подібними справами? Дякую.
I'm not aware that we have dealt with this type of cases already. Maybe my colleagues can help me out? No, I don't think so. It would be very interesting, of course.
А ви самі розглядали такі в Україні?
Ні, я просто хочу, якщо я можу, там, де я абсолютно з колега Джолінчук сказала, в Європейському суді ще не було таких справ, але дуже нещодавно була справа в Сполучених Штатах, де людину засудили саме за булінг в Фейсбуці щодо його колишньої дружини, він сів в тюрму. І суд розглядав пропорційність. І дуже нещодавно була справа в Фінляндії, теж мені здається, що вона висвітлювалася в засобах масової інформації, теж стосовно погроз в Фейсбуці. Тобто це не те, що ми сьогодні можемо з вами писати що завгодно, щодо кого завгодно, знов-таки більш прискіпливо дивляться на що саме стоїть за цими фейсбуковими, чи інстаграмовими, чи іншими погрозами, чи булінгом в соціальних мережах.
Але в майбутньому вони можуть потрапити, так, до суду?
Ну, з того, що є сьогодні дуже такий невеличкий обсяг, видається.
Мікрофон, будь ласка.
Спасибо. Тут, по-моему, вот, да, пожалуйста.
Чистякова Юлія, Національний університет Львівська юридична академія. One of the recent judgments of the court concerned that insult of Prophet Muhammad cannot be protected by the convention. And from other hand, we have the publications of Charlie Hebdo. And what are the measures? Where is insult and where is it is freedom of expression? How court looks for those two cases, and what is the answer? Where is insult actually took place, and where is it is the freedom of expression? Typical for European media.
Простите, пожалуйста.
Thank you for this question. I understood that the previous speaker on the list will go into that question, so I will leave that to him. Thank you.
Я вам хорошо отвечу, не беспокойтесь. Есть еще какие-то вопросы? Ну, должны же быть вопросы. Я так понимаю, что тут в основном аудитории люди, которые прошли серьезный, так сказать, конкурс. То мы надеялись, что вы будете нам задавать вопросы, мы тоже себя с этой точки зрения как-то проверим, насколько все понятно нашей теме. Но вопросов нету. Да.
Thank you very much. If I may ask rather, thank you very much for your brief presentation. Rather theoretical question. How do you think, what is the process of evolving rights from the concept, right? You've mentioned the right to be forgotten. We know that there are many other concepts, right to hope. And what is the usual progress of the transforming from concepts to a right? What is the process of transformation from the concept to a right? So is there a future for the right to be forgotten, to be like a full-fledged right, human right? Thank you.
Thank you for your interesting question. The development of these notions, like the notion of the right to be forgotten, they are always developed in specific cases that come to the court. So every time when a case comes to the court will have a look on what is brought to the court in the context of what is brought to the court. And of course this context